So let's start with an overview of the Hate Speech Act and why this relatively new law is so controversial. The Hate Speech Act was signed into law in May 2024. And what it does is it creates a new statutory crime of hate speech. We had the Equality Act, which has a civil hate speech offense. We had common law crimes that could be used to prosecute hate speech. But this is the first statutory hate speech criminal act. The act is not yet in operation, but by simple proclamation in the government gazette, the president just needs to sign that proclamation. It just needs to be published. It can come into operation any day. So what the Hate Speech Act does is it criminalizes certain kinds of expression with fines and or imprisonment of up to 5 years. And it's controversial because the definition of hate speech is so wide that speech or expression, because expression is wider than just speech, speech that is an expression that is rightfully constitutionally protected, in other words, lawful, including religious expression, can be caught in its wide net. Because in a criminal law, if your definition of a crime is you think about it as a net, the wider the net, the more conduct gets caught in that net. And that's why crimes need to be tightly defined, because we don't want actions and conduct that is not a crime caught in that net. As such, this act is a threat to religious freedom and expression. It's a threat to human rights in general and just democracy in general, because religious freedom and freedom of expression are key democratic rights. And a big issue with this law is that it can cause people to start self-censoring out of fear, and which stifles healthy public debate. It just stifles freedom of expression. So people are not saying things that they're even allowed to say because they're unsure, because they're afraid. So that's very problematic. Let's just go a bit deeper into the worst problems of this act. So like I say, criminalizes expression. You can go to jail for something you say, including religious expression. And we have to start by looking at how it defines hate speech. It's basically any communication that is harmful or incites harm. That's an important word, harm, and that advocates hatred against a specific group of people. The problem with the hate speech offense is that it's worded or defined in a way that's very wide, very vague, subjective, broad, ambiguous, meaning, like I said, speech that is rightfully lawful and constitutionally protected can be wrongly caught in that net, because there's a very important difference between hate speech and speech that I hate, or speech that is unpopular. That's a very important difference between that two. And this definition of hate speech is vague for various reasons. One of them is that hatred is not defined, which is surprising or shocking even, because it's the crime of hate speech. What does hate mean in the context? We can't just, with the criminal law, you can't just take any definition of hate as, what we think, what we want it to mean. It has to have a specific definition, because in each magistrate court, when a person could be prosecuted for hate speech, they need to apply the same definition, because if they are not applying the same definition, then people are not treated equally by the law. So that's very important. Then the concept of harm. I mentioned that the concept of harm, which is in this definition of hate speech, is important. It contains subjective and vague components. It contains emotional harm. So that's basically a person's hurt feelings. It contains this concept, this novel social harm, which is so widely defined. It's basically anything that undermines the social cohesion of the people of South Africa. That is incredibly wide. It's way too wide. And it's very difficult to say kind of where this concept starts and where it. Then there's a long list of prohibited grounds. So basically people or grounds on the basis of which you can commit hate speech. Now, some of them are not controversial or new, but some of them are quite novel. Some of them are quite controversial, and none of them are defined. And then this act even criminalizes private communications. And where we have the Equality Act that looks at civil hate speech, the Constitutional Court said concerning that act, it does not apply to private communications. Now, this criminal act applies to private communications. That means the bar for criminal hate speech is lower than the bar for civil hate speech. And logically, it should be the other way around. It should be more difficult. The standard before something is a crime, it should be worse conduct that qualifies for a crime. Now, we also are of the view that this act does not meet the international law obligations that protect freedom of expression and protect religious speech, and set a very high threshold for the criminalization of hate speech. There's a difference between criminalising hate speech and having civil sanctions like civil law fines and apologies and other things. Crime for something you say, there's a very high threshold, and there's very good international law and guidance on that to ensure that true hate speech is dealt with. We're not condoning true hate speech, but that it's the serious cases, and that inadvertently we are not taking away from our freedom of expression and our freedom of religious expression, very importantly. Some people might say, but isn't there a religious exemption clause in this act? Yes, there is, and the original bill didn't have one. I'm very, very grateful that this clause was put into the bill. But this clause is worded in a very circular way. And because it's worded in a circular way, it is self-defeating. It basically undoes what it tries to do. So it's practically not very useful. And we want a real, proper, robust religious exemption clause, not something that looks nice, but it's practically not very useful. So what all this does, taken together, is that this means this act is very subjective. If you have a law that is vague, it's open to subjective interpretation, which opens it to arbitrary application. That means the law will not be applied consistently. That effectively means that people will not be equal before the law, as the Constitution requires. And also it means that this act is open to abuse. It's open to be weaponized. And we are against many people, but we are particularly concerned about it being weaponized against persons of faith when they express their sincerely, deeply held beliefs, not bigoted beliefs, but sincerely, deeply held beliefs in a respectful way on issues such as marriage and sex and gender and sexual relationships, etc. So what are then the opportunities or options for doing something about the problematic aspects of this act? How can we protect our right to freedom of expression? Well, basically, there are three opportunities. The first is the wait and see opportunity. So this is where you wait for a test case to come along. A test case, if somebody is wrongly accused of hate speech, and now this goes to court, and then eventually it gets appealed until the Constitutional Court somewhere gives a final decision on the validity of the act. But this test case can only come once the act is in operation. You're not yet in operation. But there are pros and cons to test cases. The pros are that you have to wait for the law to become operable. The law, even once it's operable, can be on the book for years before a test case comes along. And in that gap, due to the uncertainty and fear, people are self-censoring, which is not a good thing. It can be a bad test case. And even if it's a good test case, it will put an innocent person through the incredible trauma and the incredible legal cost of going through a trial. And that you might also have a situation there where people are being prosecuted for hate speech, but they don't have the means or they don't know how to appeal cases properly, and they're being sent to jail for something. If that same case happened to another person, they would have appealed the case. So that's not the best option. The other option is proactive litigation. This is where you challenge the constitutional validity of the act. And we believe there are good grounds on the substance of the act as well as on the procedural grounds. But it can take very long because we have to start at the High Court, and then you go to the Supreme Court of Appeal, and then you go to the Constitutional Court. It can take years. It costs a lot of money. So perhaps not the best option. We think there's a third option, and we think this is the best option, an amendment bill. So what an amendment bill, because we have an act, then you bring an amendment bill, and the amendment bill seeks to amend the problematic aspects of the act. For that, you require political buy. I know somebody needs to adopt it and somebody needs to introduce it into Parliament, but it's perhaps the quickest way to bring about a positive change. Plus, with an amendment bill, to always go for Parliament. For example, we spoke about the marriage bill earlier. There are opportunities for public engagement. Because Parliament has a legal duty, government's legislative branch has a legal constitutional duty to facilitate meaningful engagement. So an amendment bill in the parliamentary process is very democratic if done properly. When this Hate Speech Act was still a bill going through Parliament, it was between 150,000, 200,000 submissions asking for things such as insert the definition for hatred. That didn't happen, which raises procedural concerns. Public participation cannot be a tick box exercise. Then it's not meaningful public participation. The members of Parliament, when submissions are made, they really have to apply their minds and seriously consider all the viewpoints that are put before them. So we think that's the best route. An amendment bill. We've been speaking to peer organizations who share similar concerns. We've been consulting with our legal team. We've been speaking to members of Parliament, stressing the importance of an amendment bill, really to protect religious freedom, but also to just protect freedom of expression in general. So that is what we will be contending for. And we, of course, we've also been raising awareness with our constituency, with religious leaders, the general public, various platforms, including as we're doing now. But what we will do I think our focus for the next months or so will be to continue to speak to politicians to really get this amendment bill on the agenda. Because the Hate Speech Act is probably the greatest threat to freedom of expression and freedom of religious expression since the dawn of our democracy. So it's definitely something that we cannot just leave like that.
Good day. This is Nobukosi Zulu, legal advisor at FOR SA. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.